this is Gray Hughes of Gray Hughes Investigates on YouTube. Please hit that like button, share, and subscribe. Today's video is a continuation of the videos regarding the denied Frank's motion by the defense team in the Idaho 4 murder case of Kaylee Goncalves, Madison Mogen, Ethan Chapin, and Xana Kernodle. And this happened on November 13th, 2022. And Bryan Kohberger, in my opinion, I 100% believe that Bryan Kohberger is a killer. I have no doubts whatsoever. I don't sit around and go, what about this and what about that? I did all that already at the very beginning. And Bryan Kohberger is the killer. All right. So if that offends you that I believe that, just remember what you thought about OJ or Casey Anthony, etc. And nobody said, well, it's innocent until proven guilty, Gray. Okay, you never said that, all right? And yes, in court, it's innocent until proven guilty. Absolutely 100%. But as a person in society looking at the evidence, I'm not on the jury, I believe Bryan Kohberger 100% is the killer. So today we're going to go over other elements in the Frank's motion that was denied, that was discussed in the document, and I'm going to go over each one of those right now. So the first one we're going to talk about is the defendants next assert that Detective Payne misrepresented the time defendant's cell phone stopped reporting to the network to imply that defendant was traveling towards Moscow between 2:47 and 2:54. I don't think that implied anything. It just had the phone down in that area. I remember going over that in the document and wasn't really absolutely certain what direction the phone was going, just that it was heading south in Pullman, Washington. On this point, defendant relies foremost on the affidavit of his expert, Mr. Slovensky, who states, affiant has found inaccurate information in Officer Payne's affidavit for search warrant and application for an order for a pen registry or a trap and trace device. And that was dated December 23rd, 2022. Payne makes a false statement in his affidavit. Payne states in his affidavit, Bates 003772, that at approximately 2:47 a.m., Kohberger's phone stops reporting to the network. This statement is erroneous. Payne has failed to advise the court of the following. The 2:47 a.m. traffic is a continuous 7-minute stream on multiple towers that ends at 2:54 a.m. Payne does not document this 7-minute traffic. Payne did not inform the magistrate about these handoffs, which would have clearly and directly shown him the fact that on November 13, 2022, from 2:47 to 2:54, Mr. Kohberger's device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. The fact that Payne either disregarded or was not aware of the handoff and direction of travel of Mr. Kohberger's device gives this affiant grave concern over the lack of training and experience Payne has in mobile forensics and the credibility of this affidavit. I mean, I think it's just the most, again, a ridiculous argument. We had, in this time frame, we had a 2:47 over here where his phone turned off, and in the probable cause document, they say that his phone is heading in this direction and it's heading towards Main Street, or basically Highway 270 that intersects Pullman, Washington and Moscow, Idaho. But they're saying that it shows it goes south. Okay, I can totally buy that. South is where I always thought he went. I never thought that Kohberger drove on 270 to get to Moscow, Idaho in those early morning hours. I thought he went south down in this direction. Now look at this. If he went south right here and then took a left on Sand Road, now keep in mind his phone is turned off at this point at 2:54, so he's driving and he goes on Sandy Road, and then Sandy Road drives all the way up into here, and then you're right down below where Kohberger exits the area the night of the homicides. He takes, I think he's on, Conestoga Drive, that's mentioned in the probable cause document, but on the way in, he would have driven by like this, and then turned up here, and then made his way to Indian Hills Drive. Now, it only takes about 20 minutes to make that drive. 17 actually. 17 minutes. So that would put him on Indian Hills Drive at like 3:10, 3:11, something of that nature. But he's on Indian Hills Drive at 3:26. So he could have even driven further down. Or maybe he just slowly drove across, waited and paused in different locations. We don't know. But this is one of the directions I think he may have gone, like this. And that would have him going south and then down when the phone's off, undetected. And then he's in this area, and his phone isn't pinging anymore. It's just his vehicle spotted on cameras. So right here, his phone is spotted at 3:26. Then exactly how long it takes, 2 minutes later, it's spotted right here at A&W at 3:28. Then apparently, according to Ann Taylor, at 3:29, the vehicle is spotted going in this direction. And then at 3:29 and 49 seconds or so, it drives by this camera. And then at, I would say like around 3:30 and some odd seconds, you're going to see the vehicle driving by the 1112 King Road camera like this. And that's when it makes its first of 4 different passes back here. Okay, so let's get back to the document. Defendant's other cellular expert, Cy Ray, likewise contends he has reviewed multiple search warrant affidavits prepared by Detective Payne, and his statement that defendant's cell phone stopped reporting to the network at 2:47 a.m. is blatantly false and not supported by the AT&T data. But it's absolutely irrelevant. Okay, if it stopped reporting at 2:47 or it stopped reporting at 2:54, that's consistent. It's still turned off with plenty of time to get to Moscow, Idaho. I don't even understand the argument. In addition to these 2 expert affidavits, defendant includes in his proffer the AT&T call detail records that purportedly reveal that the actual time the phone stopped reporting to the network was 2:54. There you go. Okay, 2:54. It only takes like 10 minutes to drive from there to Moscow, Idaho. So this doesn't help the defense at all. It just means that you have a 7-minute difference. Ann Taylor was like, don't let the 7 minutes fool you. It's really important. It's not. It's absolutely inconsequential whatsoever. I just showed you that it takes 17 minutes to even drive down south and across, and you're still there in plenty of time, still 10 minutes early. As an initial matter, defendant has not provided the search warrant affidavit identified by Mr. Slovensky with the proffer. The only search warrant affidavit authored by Detective Payne that defendant has provided with the proffer is Payne Exhibit A, which is dated December 29, 2022, and accompanied an application for a warrant for defendant's arrest. The court cannot consider the effect the alleged misstatement would have on probable cause without the correct affidavit before it. However, the search warrant affidavit referenced by Mr. Slovensky is otherwise part of the record in the case as to other motions, and the court will take judicial notice of it for purpose of deciding this issue. Here's what the court findings are. The court does not find defendant proffer deserving of a Franks hearing. First, defendant has not established the challenge statement is misrepresentation. Detective Payne expressly qualified his statement by noting it was an approximation only. As he testified to an earlier hearing in this matter, Detective Payne is not an expert in deciphering CDRs. Thus, he provided the records to FBI Special Agent Balance to analyze and relied on Agent Balance's analysis in drafting the pen register affidavit. That affidavit disclosed both Detective Payne's reliance on Agent Balance analysis and Agent Balance's training and experience to the magistrate. To the extent the approximation was off, a 7-minute discrepancy, particularly one occurring more than 1 hour prior to homicides, is not so far outside the approximate window as to render the statement false. Further, even if the statement could be characterized as false, defendant has not shown it to be intentionally or recklessly so. In fact, not even Mr. Slovensky goes so far to impute this mens rea to Detective Payne. Rather, he points out that Detective Payne either disregarded or was unaware of the handoff data that would have revealed the correct time the phone stopped reporting. So I'm glad the defense is admitting that the phone stopped reporting at 2:54, which makes it even closer to the time of the homicides, which seems to be another error on Ann Taylor's part. You want to have the phone turned off way before, so it seems unconnected. Now we're at 2:54, and we see the white Elantra in Moscow, Idaho on Indian Hills Drive at 3:26. Just a mere 32 minutes later. Finally, defendant has not shown Detective Payne's mistake in identifying the handoff data to be exculpatory. Mr. Slavinsky claims it was exculpatory because a correct interpretation of data would show the device was not heading to Moscow as purported by Payne, but was indeed heading southbound from Pullman, Washington. There are two problems with this assertion. First, the pen register affidavit represents that the device was traveling south at 2:47 a.m. when, according to Detective Payne, it last reported, and he wrote this, on November 13, 2022 at approximately 2:42 a.m., Kohberger's phone was utilizing cellular resources that provided coverage to 1630 Northeast Valley Road, apartment 6201 in Pullman, Washington, and that's Kohberger's residence. At approximately 2:47 a.m., Kohberger's phone utilized cellular resources that provide coverage southeast of the Kohberger residence, consistent with Kohberger's phone leaving the Kohberger residence and traveling south through Pullman, Washington. Pen Register Affidavit Exhibit A. Thus, because the exculpatory information identified by Mr. Slavinsky appears to have been represented in the affidavit, the court is at a loss at how a correct statement of the time the phone stopped reporting to the network would affect probable cause. Exactly. See, these are all the things that we were thinking when watching the hearing. Just how ludicrous the arguments were made by the defense team. I mean, they are grasping at every conceivable straw to find a needle in there, but it ain't going to happen. Second, even if the pen register affidavit did misrepresent that defendant's cell phone was headed to Moscow between 2:47 and 2:54 a.m., as opposed to southbound from Pullman, a correction would have no effect on probable cause. Traveling southbound from Pullman at 2:54 a.m., more than an hour prior to the homicides, does not disprove that defendant could have driven to Moscow after 2:54. That's exactly what I'm saying. I think you do have to put him there at 3:26, and there's plenty of time, even driving south. So again, it does not disprove that defendant could have driven to Moscow after 2:54 a.m., after his phone stopped reporting to the network. As the affidavit points out, footage from multiple videos obtained from the neighborhood around 1122 King Road showed several sightings of a vehicle matching the description of defendant's vehicle starting at 3:29 a.m. and ending at 4:20 a.m. Given the proximity of Pullman to Moscow, the fact that defendant may have been traveling southbound in Pullman at 2:54 a.m. does not exclude him as the potential driver of the suspect vehicle from a probable cause standpoint. Isn't that amazing? That's exactly what we were saying. It absolutely has no relevance at all. It means absolutely nothing. It actually extends out the time before he turned off the phone, though, which is great because now we're getting closer to the time of the homicides. All right, now here's another statement that was denied. Defendant has not met his Frank's burden on issue 12, lack of connection between defendant and victims. In issue 12, defendant challenges law enforcement omission in their exhibit as of fact that their investigation failed to reveal any connection between defendant and the victims. Defendant claims this information was material and exculpatory because it sheds doubt on law enforcement theory that defendant was the right person. I mean, this is absolutely insane. Did Bundy know his victims? Did Jeffrey Dahmer maybe know them before he picked them up at the bars? I mean, none of these people know their victims prior. Knowing them prior is irrelevant to me, okay? However, defendant has not established the lack of connection was a fact conclusively known to law enforcement at the time the search warrant applications were submitted. So I guess what they're saying is the search warrant was to see what led Kohberger to go to that house, and maybe they were trying to find something. Now, them not finding a piece of information that shows that he knows them doesn't mean a damn thing. Thus, he cannot establish it was intentionally or recklessly omitted. Moreover, this omission was not material or exculpatory. Had law enforcement found a connection between defendant and the victims prior to applying for search warrants, it is reasonable to assume the connection would have been disclosed in the search warrant affidavits. The fact it was not disclosed necessarily allowed the magistrate to reasonably infer that no connection had yet been found. Yet she still found probable cause to authorize the search warrant, as was reasonable to do. Consequently, defendant has not carried his burden under Franks on this issue. So, right, in the probable cause it didn't mention any connection. So not putting in that there isn't a connection isn't necessary, because you would assume that they couldn't find a connection at the time of the affidavit. So again, Ann Taylor grasping at the proverbial straw. All right, here's another one. Defendant has not met his Frank's burden on issue 6, dog barking. In this issue, defendant challenges omissions pertaining to the barking dog, referenced in the Payne exhibit. It states that at 4:17 a.m., security camera located at nearby residence on King Road picked up distorted audio of what sounded like voices or a whimper followed by a loud thud. A dog can also be heard barking numerous times starting at 4:17 a.m. The only information in the Payne Exhibit A pertaining to a dog refers to the fact that Kaylee Goncalves' dog Murphy was found in her bedroom by first responders. Defendant contends that Detective Payne failed to include 3 allegedly important pieces of information pertaining to the dog. This sounds right out of the Kohberger playbook, The Conspiracy Nutters. That the dog heard on the security camera continued to bark for 30 minutes after the suspect left. Because there's no other reason a dog might keep barking. It has to be that there's another killer walking around at that point. That the dog heard on security camera continued to bark for 30 minutes after the suspect left. Wow, that's astounding, because dogs just usually stop barking when their owner is dead in another room. That Detective Payne conducted a test to determine that the dog was likely outside while barking. And 3, that Murphy was found without any blood on him, even though the bedroom doors were open where the decedents were found. According to defendant, this omitted information would have revealed that whoever was in the house brought the dog back inside after the suspect vehicle left. He further argues this information is material and exculpatory because it undermines the narrative and timeline that supports probable cause. I couldn't disagree more. It's just an absolutely, again, a horrendously idiotic argument attempt. However, defendant's argument assumes, without proof, there were no doors left open in the home after the suspect left. This assumption is not only speculative, but contrary to evidence in his proffer that the sliding glass door to the residence, the same door towards which Dylan Mortensen reportedly saw the suspect walk, was left open. So now we know that the sliding glass door in the kitchen was left open after Kohberger left the residence. Couldn't it be that the dog was just barking at Kohberger as he was going up the hill? He followed him down, perhaps, or followed him out of the residence, or went outside after the dog heard the car drive away. Maybe it was barking inside. We don't know. But apparently, if they did a study that the dog was outside when it was barking at 4:17, then that would likely be the time Kohberger exited the residence, and the dog perhaps went out and started barking on the patio down below, and Kohberger was over getting into his car up above. So let's see. However, defendant's argument assumes without proof there was no doors left open. And we just read that the sliding glass door was left open. Thus, if the dog heard barking was in fact Murphy, it could well have come back inside through the open door and gone into Miss Goncalves' room on his own, where it evidently remained. There is simply no evidence to adopt defendant's speculation that someone brought Murphy inside after the suspect left the residence. It almost seems like Ann Taylor's reading and watching, a literal clown on YouTube and, other YouTubers or something, because this is just absolutely ridiculous. Consequently, defendant has not shown that the failure of law enforcement to so speculate was a material and exculpatory omission that was intentionally or recklessly excluded. Frank's hearing is not warranted on this issue. And then here is another issue. Second, defendant takes issue with Detective Payne's focus on suspect vehicle 1's lack of front license plate. In Payne's Exhibit A, he discussed his review of surveillance footage, noting, "A review of camera footage indicated that a white sedan, hereafter suspect vehicle 1, was observed traveling westbound on Steiner Avenue and at Idaho State Highway 95 in Moscow approximately 3:28 a.m. On this video, it appeared suspect vehicle 1 was not displaying a front license plate." Now, this is the video from the A&W. So if we were to go back here, this is 3:28 as the car was driving by right here. This is the A&W, and apparently this camera, they determined it wasn't showing a front license plate, and it would have been driving this direction. Detective Payne later points out that defendant registered his 2015 white Elantra with Washington State on November 18th. So this is just 5 days after the murders. He noted that previously the vehicle was registered in Pennsylvania, which, unlike Idaho and Washington, does not require a front license plate to be displayed. Defendant contends that although Exhibit A makes it appear that law enforcement was focused on the lack of a front license plate early on, it was not until after he was identified through IGG that it became an object of inquiry. In neither example has defendant established Detective Payne's investigation timeline to be misleading or false, much less intentionally or recklessly so. There can be no question that defendant was identified in part through the WSU officers' queries and through the suspect vehicle's lack of a front license plate, as observed in surveillance video from the night of the murders. The fact that law enforcement, so right here, the judge is letting us know that you can tell in the video that there is no front license plate on the white Elantra that's driving around. The fact that law enforcement had additional DNA evidence tying defendant to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. It would arguably be irresponsible for law enforcement to rely solely on DNA evidence without making an effort to corroborate it. Particularly given the novelty of IGG, defendant has not established there is anything wrong with this approach. And it says, see United States Taylor 63 5.4 637 648 7th Circuit 2023, observing that requirement under Franks that search warrant affidavit be truthful and complete does not require that every fact recited therein be correct or that every detail of investigation be provided. Indeed, what is important to probable cause is the totality of the evidence once all gathered and examined in light of what that collection of evidence shows, not looking at it in isolation as each piece of evidence was separately gathered. Moreover, had law enforcement indicated in Exhibit A that the WSU query and lack of a front license plate only came across its radar after defendant had been identified through IGG, defendant has not explained how this would have eroded probable cause. And then it continues on. Indeed, as discussed below, including the IGG evidence would have provided more, not less, probable cause supporting the search warrant. Consequently, a Franks hearing is not warranted on this issue. And again, just a ridiculous argument. And they didn't determine it was Kohberger until they investigated him. So the IGG led to a name. Then they had to do normal investigative techniques. And in that investigation, this is prior to his arrest, they looked him up. And they found that, he drove a white Elantra. They found that he didn't have a front license plate. They reviewed different traffic stops, and it showed in one of them that he didn't have a front license plate on. Then in surveillance, a white Elantra driving around doesn't have a front license plate. And they put all of this in the probable cause affidavit because after looking into Kohberger, he became likely to be the killer. And they wanted to be able to search into elements of Bryan Kohberger. So this just appears that Ann Taylor is really struggling to find a good argument. If you're a believer in the defense in this case, and you see these types of arguments, you'd have to be really nervous for your buddy Bryan Kohberger, because these are some of the weakest arguments I've ever heard, and that means they have nothing. So in the probable cause affidavit, it mentions that, just a quick recap here on this last portion. On this building right here, the A&W, this is an older video, so it's not going to show it, but if you go back, there's a newer one, like, that one right there. This one is from 2018. On this one, you can see, I think this one's even newer. This one's 2024, and so there's cameras up here. There's one there, and I believe there's even some on the side over here, maybe right there and there, I can't remember, but I've been there and looked, and that camera shows that it's missing a front license plate. And apparently, when it's driving by right here, maybe you can even see the same thing. Who knows if you can see it on the 1112 King Road camera. I don't know, because I've actually seen still frames and the front headlights blow it out, but I would assume during the 3-point turn that it makes at around 407-ish, you'll be able to see the profile of it and determine that that is a white Elantra. Okay, so anyways, thank you guys all very much for watching the video. I hope you guys found it interesting. And as I always say, until next time, be safe out there.